Welcome to another podcast of the Riffle series. The Riffle, a podcast series brought to you by 10 Leaves. And welcome to the deep dive. Today we're cracking open some really significant potential changes brewing in the Dubai International Financial Center, the DIFC.
That's right. We're looking at proposed amendments to the real property law, the RPL, and its regulations, plus some operating regulations that have already changed.
Okay, so this is, well, it's pretty crucial stuff if you're involved in property, finance, or really any business operating within the DIFC, isn't it? I mean, it's the major financial hub for the whole MESA region.
Absolutely. And the stated goal, coming from the DIFC Authority's chief legal officer, Jacques Yazer, is all about bringing greater clarity, fairness, and flexibility.
Clarity, fairness, flexibility. Okay, so our job today is to dig into the specifics behind those words, right? What's actually in consultation paper number 3 of 2025 that delivers on that?
Exactly. But first things first, we absolutely need to separate what's proposed from what's already done.
Good point. So what's already in effect?
The enacted change involves the operating regulations. This went live back on October 28th, 2025. Essentially, following a directive from the Dubai Supreme Fiscal Committee, the DIFC Authority, DIFCA, has been mandated to collect a specific sales fee.
Okay, a specific sales fee. From who and how much?
It's a 7% sales fee, and it applies to hotels and other establishments within the DIFC that serve alcohol.
Ah, right. So places like hotel bars, restaurants with licenses.
Precisely.
Yeah.
And the key operational shift is who they pay it to. Before, this fee went to the Dubai Municipality.
Yeah.
Now they pay that same 7% fee directly to the DIFC Authority.
Got it. So for those businesses, the amount hasn't changed, but the process has. They now report and pay straight to DFC. It's about centralizing things within the center.
Exactly. Streamlining the collection. That's the reality now. Okay, so now let's pivot to the proposed changes, the ones affecting the real property law and regulations. These are more about, well, easing burdens and tweaking risk.
Right. Let's get into focus area 1. Flexibility and reducing financial risk. You mentioned easing administrative burdens. Sounds like they've heard some feedback that things were maybe a bit too tight.
Seems that way. Let's start with lease registration, a very common process. The proposal is to extend the deadline to register a lease. It's currently 30 days.
And they want to move it to
45 days.
45.
Okay, 45 days. That feels like a decent bit of extra breathing room. Is this the first time they've adjusted this?
Actually, no. And that's interesting. It went from 20 days to 30 days back in 2024.
So they're finding that even 30 days wasn't quite enough in practice.
Apparently. You know, lessors sometimes face delays, documentation complexities, third-party holdups. This suggests 45 days is seen as a more realistic window to get everything done properly.
Makes sense. You want compliance, but practical compliance.
Okay, but what if you still miss the deadline? Even the new 45-day one. I hear there's a big change proposed for penalties here. Something about fairness?
Yes, this is quite a significant shift. Currently, failing to register a lease, like several other minor breaches, falls under a sort of catch-all penalty.
Which is?
A flat $1,000, which, can feel pretty steep for what might just be an administrative oversight.
Ouch. Yeah, $1,000 for missing a deadline by a day or two seems harsh.
Right. So the proposal is to completely remove that specific failure, failing to register a lease from that $1,000 penalty category.
Okay. So what's the new penalty?
They're proposing a new dedicated penalty just for this. It's much lower, only $100.
Wow. Okay. From $1,000 down to $100, that's a big difference. Is the idea just to be less punitive, or is there a risk people won't take it seriously?
I think it's about proportionality. They still want you to register on time, hence the $100 penalty is not zero. But it avoids that really disproportionate financial hit for a simple administrative slip. It feels more like encouraging compliance rather than punishing heavily.
Yeah, that recalibration definitely fits the fairness theme.
Are there other timeline alignments happening? Thinking particularly about off-plan sales. Yes, good point. Off-plan sales are common, and there's a proposed change there too. It relates to paying the Freehold Transfer Fees. The deadline to pay those fees for off-plan purchases is proposed to increase from 30 days up to 60 days.
60 days. Why that number?
Well, it's about consistency. Back in 2024, they already extended the deadline for registering the off-plan sale itself to 60 days.
Ah, I see. So this just aligns the fee payment deadline with the existing registration deadline, makes the whole process smoother.
Exactly. One clear 60-day time frame for both registration and fee payment for off-plan deals. Logical.
It's those kinds of details that matter for advisors trying to keep everything straight. Okay, and speaking of tidying things up, there was something mentioned about caveats. removing an application and a fee. What's a caveat, first off?
Right, so a caveat is basically a legal notice lodged against a property title. It signals that someone, a third party, claims an interest in that property. It kind of freezes any transfer until that claim is sorted out. It's a protective measure.
Okay, so what's being removed?
Well, way back in 2018, the actual right to apply for a caveat to lapse, basically, to cancel it, was removed from the real property law itself.
But
But somehow the application form and the associated fee, which was $545, they just stayed on the books. It was an inconsistency.
so you could still technically find the form and the fee, even though the legal basis to use it was gone.
Pretty much. So this proposal just cleans that up, removes the defunct application, removes the pointless $545 fee. It's pure administrative housekeeping, fixing an old oversight.
Got it. Streamlining and tidying up. Okay, that covers the administrative east side. Let's move to the second big area. Legal liability and fairness powers. This sounds more fundamental.
It is. These next two proposals touch on risk allocation in construction and introduce a really interesting discretionary power.
Let's start with the construction risk. What's changing there? I see the term decennial liability.
Yes, decennial liability. It refers to a 10-year liability period. The proposal is to introduce this specifically for structural defects in buildings. And crucially, this statutory liability would apply directly to contractors, making them liable towards the developer for those 10 years.
Okay. How did this work before in the DIFC? Wasn't there already protection?
While the RPL already handled the developer's liability towards the end purchaser, that was covered. But the link between the developer and their contractor, that liability, especially for structural defects over a long period, generally had to be established through contract. You needed robust wording in the construction agreement.
So if a developer didn't negotiate that specific 10-year liability passed down strongly enough in their contract with the builder,
They could potentially be left holding the liability themselves, even if the fault lay with the contractor's work. Yes.
okay, so making it statutory means it applies automatically by law.
Precisely. The developer doesn't have to fight to get it into the contract anymore. It's just there. This actually pulls in elements from the onshore UAE legal system, specifically Article 880 of the Civil Code, which deals with this architect-contractor liability.
So it harmonizes the DIFC position somewhat with the wider UAE framework on this point.
Exactly. It creates more certainty for developers and aligns expectations across the board for major construction projects. Less reliance on complex contractual drafting for this specific major risk.
Interesting. A significant shift for developers and contractors. Now, the final piece, this general waiver of power for the registrar. This sounds potentially huge.
It really is a major conceptual shift, I think. The proposal is to give the Registrar of Real Property, the RRP, a general power to waive certain things.
Waive what specifically?
Specific requirements under the law, penalties, or conditions imposed by the RPL or the regulations.
Whoa. Okay. But wait a second. Isn't the whole point of the DIFC, its big draw, the certainty of its common law system, black and white rules, doesn't giving an official the power to just waive the rules potentially introduce uncertainty?
That's the million-dollar question, isn't it? And you're right, the DIFC's reputation is built on that predictability. But the justification presented is that there are situations where rigidly applying the letter of the law, especially automatic penalties, can lead to genuinely unfair or unjust results.
Can you give an example?
Sure. Think back to that lease registration deadline. Imagine a lessor has everything ready, totally prepared to file on day 29 of the 45-day period. But they need one final sign-off from, say, an external entity, maybe a government department, outside the DIFC, and that entity causes a delay of 3 days.
Okay, so the lessor misses the deadline, but it's not really their fault.
Exactly. Under the old rigid system, the penalty, whether it was $1,000 or the proposed $100, would likely apply automatically, even though the lessor did everything they could.
Right. And this waiver power would allow the registrar to look at those circumstances.
Yes. To look at the situation and say, okay, applying this penalty here would be unfair given the external factors. It allows for discretion, for common sense, you might say.
So it's not about rewriting the law on a whim, but about handling edge cases where a mechanical application creates injustice.
That seems to be the intention. It's aimed at mitigating those situations where strict adherence leads to an inequitable outcome, particularly concerning penalties or conditions where a party was genuinely prevented from acting. It injects flexibility.
A significant dose of flexibility into a system known for its rigidity. It definitely reflects that fairness goal they mentioned.
It certainly does. It shows a move towards perhaps a more principles-based application in specific circumstances.
Okay, so recapping these proposed changes, the longer lease registration, the lower penalty, the aligned off-plan deadlines, the caveat cleanup, the contractor liability, and this new waiver power, these are all currently out for feedback, right?
Absolutely critical point. These are proposals in consultation paper number 3 of 2025. They are not final law yet.
And there's a deadline for people to provide their thoughts.
Yes, and it's coming up fairly soon. The public consultation period is open now, and comments need to be submitted by November 30th, 2025.
So if you're a developer, a contractor, a lender, a lawyer, anyone operating in the DIFC property space, now is the time to review this and share your perspective.
Definitely. Views should be sent to the Chief Legal Officer, Jacques Visser. The email address is consultation@dif.ae.
Consultation@dif.ae, got it. And after November 30th,
DIFCA will review all the feedback received. They might make further tweaks based on that input, and then eventually the final amended law and regulations will be formally enacted and published with an effective date.
so input now could genuinely shape the final rule.
It really could.
Okay, so as we wrap up, let's just circle back to that general waiver power. It feels like the most profound potential shift. The DIFC built its global standing on predictable common law rules. How might introducing this explicit power for the registrar to deviate, even if only for fairness or equity, change the way businesses perceive risk and certainty in the DIFC? Is it a positive step towards practical justice, or does it introduce a subtle element of unpredictability?
That really is the core tension, isn't it? Does pragmatism enhance certainty, or does discretion undermine it? It's something we'll definitely need to watch closely as it plays out.